Good afternoon, everyone. We'll be with you in one moment. We're just waiting for Matt Heel to return. No? We're okay, we can start. Okay. So, good afternoon. We now have Transpower online. I've got written down here, there's Sarah and Ainsley and one other. So this morning, for the benefit of the Transpower team, I don't know if you're able to join in with us. We were had a little bit of an issue in terms of Courtney Bennett being caught by weather and flight disruptions. So basically we've been focusing on the legal submissions and now ready to hear from Transpower. So we'll hand over to the three of you to proceed as you wish. We have been through the evidence, but we've received a lot of evidence in the last week. So it would be helpful just to have an overview from each of those who are speaking at the appropriate time, but in your hands. Thank you.
Kia ora koutou, good afternoon. I'm Sarah, Sarah Scott, I'm legal counsel for Transpower. Ainsley McLeod is online and she has filed a statement of evidence. And Rebecca Eng is also online. Rebecca is the technical lead of policy across New Zealand for Transpower. I understand there potentially might be some questions about the ACRE model that Transpower utilises, and Rebecca is prepared to talk through that if that's something that might assist you today. I will start. I have filed some legal submissions and I assume you might have had a chance to read those, but I will take you through them, welcome any questions as we go, or at the end if you prefer. This is my first appearance in front of you, so I haven't had the chance to experience the way that you work, but I'm happy to do it as you like. Transpower is a state-owned enterprise that has nationally important assets in the Gore district, and it may need to construct new assets in the future. So in terms of our engagement in this particular hearing topic, I think we bring a little bit of a different perspective to what you might have been hearing from some other submitters in respect of the question of whether sites of significance to Māori should be mapped or not. I really do want to emphasise that Transpower does not fundamentally oppose the recognition of Ngāi Tahu cultural values and decision making across the district. But what my legal submissions do, and also supported by Ms McLeod's evidence, is to, I guess, bring up some practical implications and also some relationship problems to do with the Transpower's national environmental standards. So the three key things that I'm going to address, the first is in respect of the national environmental standards for electricity transmission activity. We call them NESETA, and these are relevant to existing assets within the district, existing transmission lines that were operated or could be operated in 2009 when the NESETA was first gazetted. So they are relevant. They essentially provide a set of rules that Transpower needs to consider when it wants to do things with those existing transmission lines. And if it requires consent, the objectives and policies in the district plan are directly relevant to those consent applications. So that's the first one, which I'll come back to. The second point is that Transpower is a requiring authority and at times uses the designation pathway to secure approvals for new projects. So I'm sure you'll all be familiar with designations, but in those cases, the rules in the district plan are not relevant, but the objectives and policies in the district plan are. I I guess I'd highlight that the issues that we raise in respect of designations and requiring authorities would also be relevant to other infrastructure providers that are responsible for linear infrastructure such as roads or railways, for example. The third point is, I guess, it's to do with the workability of the provisions, and it's questioning whether the approach which has been supported, I understand, by Council and the Runanga is more so business as usual in terms of enabling consideration of cultural effects and decision making rather than including that in the plan, but also having another layer that focuses on significant cultural sites and areas, which is what we commonly see elsewhere across New Zealand. So before I get to those 3 points, in section 2 of my written submissions, I do have a section on compliance with the National Planning Standards. I understand that there has been submissions advanced on this morning, but in essence, what the key takeaway that I have there is that if you refer to my paragraph 2.2, I've set out there a number of mandatory directions for district plans that are in the National Planning Standards, and Part 4, Direction 3, states that unless otherwise specified, chapters and sections that are grey in Table 4 must be included if relevant to the district plan in the order shown. And Table 4 of the standards shows the SASM chapter in grey text. And on this basis, the evidence of Ms. Barron for Hokonui Runanga is that the inclusion is not a mandatory requirement, and that a separate direction 18, to do with district-wide matters, allows for the inclusion of the NTCV chapter. I don't think we're suggesting that you can't include the NTCV chapter as well, but I think that evidence is at odds with the evidence for the Runanga and also parts of Mr. Lecky's submissions that, and indeed actually the notified SASM Objective 1, which say that all land, water bodies, natural features and marae within Gore District are recognised as sites and areas of cultural significance to mana whenua and or tangata whenua. So that there is evidence essentially before you that all of the district is a site or area of significance to Maori. And with that evidence, I submit that in itself tells us that the chapter is relevant to the Gore District. And in my submission, what is relevant should be determined on whether there are sites of significance, sites and areas of significance to Maori within the district, and not be related to the regulatory response which might be included in the plan as a consequence of that. I don't want to give that too much more airtime. It's not a key focus of our case, but I think that part of the National Planning Standards is important. So turning to the district plan's relationship with NACETA. So as I mentioned, the set of regulations is relevant to all existing transmission lines within the Gore District, except for the Gore-Hardtee line. And that's set out in Ms. McLeod's evidence. So the NACETA sets out a framework that applies across New Zealand, and it includes various activities that relate to the operation, maintenance and upgrading of those lines. And Ms. McLeod has identified that there are parts of NACETA which cannot be applied without SASMs being identified in the proposed district plan. And her example is Regulation 35, and that relies on the definition of historic heritage area in NACETA, which includes an area that is protected by a rule because it is a site of significance to Maori. And then the regulation 35, it provides that earthworks relating to an existing transmission line, which includes a site or area of significance to Māori, is a restricted discretionary activity, and one of the relevant matters of discretion is the effects on historic heritage, which of course would include any effects on the reason why the SASM is identified and the values that mana whenua hold important to them. So if SASMs aren't identified or met, then that type of regulation can't be applied. The legal submissions presented on behalf of the council this morning, I think are a little bit dismissive of this concern from Transpower. They suggest, well, if nothing's met, then that particular rule cannot be applied in this district, which I'll be interested in the Runanga's position on that, but I would have thought that the council would be wanting Transpower to seek consent for activities that it might need to do to its existing lines if they happen to be located in a site of significance to Māori. There is also a potential risk, I think, that the approach means that the district plan would be more lenient than the National Environmental Standard allows for, and sections 43B and 44A of the RMA only allow for that if the National Environmental Standard specifies that. I mean, essentially, the reason I think there's a question mark as to whether the approach is more lenient is that the rule simply can't apply. Consent wouldn't be needed. And I think I can speak on behalf of Transpower in saying that it is very uncomfortable with the suggestion that it simply wouldn't need to seek consent for this type of activity if it is in fact located within a significant area. So that's something I think to think about, and Ms McLeod can answer more questions from a planning perspective if that would assist. Actually, just before I move on, I see that there has been a redraft of it was policy MWP1 and it's now NTCVP1, which has the legal submissions referred to refined. The activities referred to in that policy, I think it's and respectively a little bit more than refinement. There are some quite significant changes in there, and there are new activities. So I think that needs to be carefully looked at. But the most relevant one from Transpower's perspective is subclause I, which is significant expansion to existing infrastructure. And that has been proposed to be works associated with existing infrastructure that breach required standards, or new infrastructure near the Mataura River, or significant natural features or landscape or archaeological sites, or not otherwise anticipated infrastructure. In respect of NACETA consents, that change I think does have an impact, as it suggests that any work associated with existing infrastructure, which of course is the purpose of NACETA, this policy is saying you do need consent. But if you look at the disconnect between NACETA and the plan, because it's not mapped, there is no connection. So that's a concern for us, and I think that's perhaps a real example of the inconsistencies the inconsistencies that have been raised by Transpower. Okay, turning to section 4 of my legal submission. So this is the focus on designations. So this is, I guess, requiring authorities and how they operate sometimes, I guess, get a bit of a backseat when it comes to preparing plans, but it's a slightly different viewpoint in that we are really focusing on the objectives and policies. if Transpower wanted to seek a new designation. And Ms McLeod's evidence refers back to earlier evidence provided, I think, in the strategic directions hearing on how Transpower needs to be responsive and due to changes in industry and demand, particularly in Southland, there's a real potential for a new line that would maybe need to go through the Gore district in the future. So we can't rule that out, and that's a lot of the work that we do from a policy perspective around the country, essentially ensuring that there is a pathway available if Transpower does need new infrastructure or to upgrade existing infrastructure. So in respect of the issues that have been raised, I understand that there's been some questions earlier which have sort of suggested, well, just change your process. It's sort of a problem for you to work out, but I think it's important just to go back to section 171 of the RMA, which is what a decision maker needs to look at when you lodge a notice of requirement. When you do that, the council will put together a panel, and the panel will make recommendations on any submissions made on the notice of requirement. So whilst Transpower as the requiring authority will make the final decision, there is that step in the middle where the council does make recommendations. As part of that, the council must consider, when considering the notice of requirement and the effects on the environment of allowing the requirement, whether adequate consideration has been given to alternative sites, routes and methods. That aligns with Policy 4 of the National Policy Statement for Electricity Transmission, which is similar, but is also explicit that Transpower and any decision makers, when they're considering a project from Transpower, must have regard to the extent to which any adverse effects have been avoided, remedied or mitigated by the route, site and selection method. I will leave Ainsley and perhaps Rebecca, if that's okay, to talk about the ACRE model. But in practice, what it does is, if Transpower was considering a new project, a starting point would be that the whole district would probably be within the sort of area that Transpower would first be looking at in terms of mapping all matters of national importance. I was involved in the North Island Grid Upgrade project, a project of national significance a number of years ago. Almost half the North Island was the sort of start point in terms of assessing the wider area. And what Transpower will do is they will look at all of the matters of national importance so that they can essentially seek to avoid them with the new project. So there's sort of two options we have here. So they might try to avoid outstanding natural features, outstanding natural water bodies, outstanding natural landscapes. Normally they would seek to avoid SASNs that are mapped in plans, SNAs, those types of things. And it would all get thrown in the mix, and we'd do our best to stay away from it, essentially. So if they aren't mapped, Transpower will need to come to the Runanga almost with an open book and say, we're looking at this new project. Can you please tell us the parts of your district that are the most important so we can try and stay away from them? Essentially asking, I guess, for the information that would normally be mapped in a district plan. The alternative is that, I think, this is from a sort of practical perspective, is that Transpower would undertake that desktop analysis, and it would identify all of the matters of national importance that it could, and it would seek to respect them and their values as far as possible, seek to avoid them, which is what the NPSET requires of it. However, sites in areas of significance to Māori wouldn't be in the mix at that point in time. And whatever spits out the end of that process, I guess, is what Transpower would then take to the Runanga and say, okay, we've done all this work, which is actually quite a lot of work. What does that look like for you? And there's a real risk there, I think, that is reducing the focus and I guess respect to the Runanga in terms of that wider process. So I hope that assists a little bit in terms of the concern that we are phrasing in that respect. In terms of Section 5 in my legal submission, so this is the workability of the activity-based approach. So I think it's important just to emphasise that the approach that's included in the plan and in your recommendations has to be the most appropriate way to achieve the purpose of this Act. And amongst other things, you do need to assess the efficiency and effectiveness of the provisions. And, you know, for plan clarity purposes, it's essential that any terms, standards or restrictions, whether they be the matter of discretion that's proposed, is set out with sufficient certainty so as to be able to determine compliance. So I just want to, I guess, make it clear that in terms of efficiency and effectiveness, if there was a recommendation from the panel that SASMs need to be mapped, then the, I guess, resource and time, etc., that takes is not relevant to that assessment that you have to undertake under Section 32. It is the efficiency and effectiveness of the PDP provisions themselves when they have been implemented by plan users. Ms. McLeod, I know evidence has raised a number of issues with NWP1, and it's encouraging to see some of those concerns being picked up in the Ms. Beerin's revised evidence. I'm not going to, I don't think, involve ourselves too much in terms of the scope concerns that have been raised, but I did want to make one observation, and that is, I don't think it's so much where these provisions are located and in what chapter. I don't think that's probably the big problem here. I think the scope from my perspective issue is whether NWP1 is expanded from what it was at notification in terms of the activities that might be covered, and whether it was always anticipated that the activity rules that have the matter of discretion in it were already covered by NWP1. So is NWP1 being expanded in a way that wasn't anticipated, either at notification or via submissions? And then the same for the actual rules that have the matter of discretion included in it. I think I'll leave the other legal counsel to argue the rest of the scope issues that are before you. I have one final point I just wanted to respond to, which is raised in the legal submissions presented, I understand, on behalf of the council this morning, and that is that the statement in there that it is for the Runanga as mana whenua to identify its cultural values in the district. I wholeheartedly agree with that statement, but I think it requires a little bit more thought, and I'd just like to work through that for you. So this is essentially a reference through to the rule of reason approach, and I understand there's been some questions about it this morning, but that rule of reason approach to assessing tangata whenua evidence is firmly established. It acknowledges the particular cultural context in which cultural evidence, especially from Kaumātua, is formulated and given, and it in effect requires decision makers to assess the evidence for reliability by testing it with reference to matters that are in accordance with Te Ao Māori. The case law that we have, and that's also referred to in the District Council submissions, they are about actual projects, so consents, and they certainly apply if you have a particular consent application in front of you. And the evidence from mana whenua is whether a particular activity may impact on values of importance to mana whenua, and if that's before the decision maker. And I can talk to a couple of cases, one in which Transpower has been involved in. But I think it's important that, of course, this hearing is about what are the most appropriate provisions are to go into the district plan. I think the rule of reason applies here. There's absolutely no reason to distinguish it on that basis. But I would add that matters such as efficiency and effectiveness and, you know, Section 32, other parts of Part 2, etc., are also relevant to your recommendations. In terms of the evidence that you have before you, I understand that the cultural evidence that the legal submissions from the council are referring to is from Mr. Terry Nicholson. And I've gone back and have a read of that evidence and also the evidence he's filed in earlier hearings. And with respect to Mr. Nicholson, that I think that evidence supports the policy approach that has been advanced by the Runanga, and that's okay, that's fine. But that isn't evidence that goes as far as giving cultural evidence that ties the relationship of Māori through to all of the district, given that the rules that will include the matter of discretion will apply district-wide. What you would, I guess, well, what I have commonly seen in other policy processes is really detailed cultural and historic evidence as to the particular values that mana whenua hold and the relationship of Māori with particular water, particular sites, particular waihetapu, and other taonga. And I don't think we have that in respect of the whole district. And I do apologise if it is before you and I have missed it. As I said, this is the first hearing I've been involved in, but from what I have seen filed in this hearing, I don't think I've sort of seen the evidence that the rule of reason is really referring to. I think that's probably enough from me. I can refer to I can talk through a couple of cases, where the rule of reason has been really important. But I think there has been, you know, really detailed, extensive evidence from tangata whenua about the particular values in question. I'm not aware of any case law that takes that as far as saying this is the regulatory response we want written into the district plan, and that can't be challenged. Sir, they are my legal submissions. Happy to answer any questions. Otherwise, I will either pass to Ms. Eng if you would like her to talk about the ACRE model further, or to Ms. McLeod.
Thank you, Sarah. There is some overlap of questions that the panel has between some of your submissions and what Ainsley McLeod is going to be talking about. So I guess I'd invite from the panel only questions that stick to the legal issues, not the ones that overlap. And in that regard, the question I've got for you is that the national planning standards require the mana whenua to identify the sites of significance if you're having a SASM chapter. What tools are available to us legally to enforce them to do that?
Very interesting question, sir. I mean, there is scope within the submissions that you have before you in terms of that relief being included in the plan. And I mean, I guess if there was a regulatory gap, that would create I would suggest a very real risk for the Runanga if they didn't want to go ahead and you know, identify the sites for you so that they could be included in the plan. I think I anticipate, if I put my council hat on, acting for other councils around the country, that you, as the panel, do not hold the power to, I guess, require them to go away and do that work. You can put some quite firm language in your recommendations, but I don't think you can. I don't think there's really anything that can I guess enforce that outcome.
So given that response then, and that has been their response, that they don't wish to do it, then it really doesn't provide us with an opportunity to have what is a traditional SASM chapter. Where would that sit then in terms of the approach that they have promoted of looking at activities and the impact on values? Is there anything from a legal point of view that you can advise us that doesn't cross over to the planning that we'll get to in a few minutes?
Nothing. I don't think I've got a very useful answer for you there, sir. I think it comes back to, I mean, if there is a gap in the plan, and that is something we've raised, is you know, are we actually creating a gap in the proposed district plan here? And it's kind of, I mean, we're saying that in terms of that having a higher regulatory effect on Transpower. It's not like we're here saying, hey, we want less, you know, regulation applying to us. I can't see. Yeah, I mean, I'm not the one coming to you with, I guess, the full solution, which the council lawyer would normally do. I'm trying to raise the practical problems from a different perspective to what you're receiving. If there is a gap there in terms of ensuring that mana whenua's, you know, interests are protected and appropriately considered in decision making, and I mean, I would have thought the Runanga would be quite concerned about that, but it is for them to say that they're comfortable with this approach. I respect that.
Thank you. Any other purely legal questions from the panel?
Yeah, I've got questions from working through your legal submissions, if we could do that together. So the first question I've got is actually from your paragraph 1.8. And I just wanted to ask you, do you agree that Section 6E itself does not contain a significance test, and that identifying activities of significant concern as opposed to significant sites and areas is a valid way to differentiate relationships to wai, whenua and taonga and effects on those relationships? So step one is, do you agree that Section 6E itself does not contain a significance test?
No, I agree. Section 6E doesn't include reference to significance, no.
The next bit was then that identifying activities of significant concern as opposed to significant sites and areas is a valid way to differentiate relationships to wai, whenua and taonga and effects on those relationships. In other words, it's another way to manage the relationship with these wai, whenua and taonga, that identifying activities of significant concern is a path, and then another path which is identifying significant sites and areas as an available way to give effect to Section 6E.
I think it's important to focus on, and I have made this submission to you before, Commissioner, that Section 6E is about the relationship that Māori have with ancestral lands, water sites, etc. And that's a really key part of Section 6E. What Section 6E doesn't do, I think, is provide a direction that you go away and find the activities that might be of the highest concern. It's really important. It's focusing in on relationships with particular water, particular sites, particular wāhi tapu, and so on. And it is, I think, that is the concern that what we've raised, and I understand other submitters are too, is that we actually won't know if we are on a piece of land where Section 6E is triggered until there is a consent application in the works.
So I think that's kind of important to help me understand where your thinking is at, because obviously the evidence in front of us is that wherever you go in the district, you are encountering lands and waters that Hokonui and Ngāi Tahu are in relationship with. So that's the evidence that's in front of us. So it's not that Transpower is going to enter some piece of land somewhere in the district where that is not the case, based on the evidence that we've got from Hokonui. So one other question I had then was, because different plans in different parts of the country have to grapple with this giving effect to Section 6E, would you agree that there are a variety of responses in planning tools and mechanisms to do that, one of which is mapping sites and areas of significance to Māori, but that's one mechanism?
Yes, it is, and it's certainly, I think in all of the processes I've been involved in the last few years, is the approach that has been taken. And I would add that what we're seeing a lot more of is it's if you have an identified area, that doesn't mean that any activity within that area might require consent. What we're seeing is quite sophisticated approaches where it is only activities that are of concern that would actually require consent within that identified area. So I think the theme that I'm hearing is it's not all activities that will have this matter of discretion, it's only some of them, the biggest problem ones. I think that is actually what's happening elsewhere in the country, where it's only a limited number of activity rules that would trigger in any case. And I'm also aware of one proposed plan where they have got down to the level of detail where it's not even just, for example, earthworks within any identified SASM. It is actually, they have taken a more nuanced approach in terms of identifying the particular activities for the particular thing that is protected. So yeah, I think which I thought was quite very nuanced. So yes, I agree. I'm seeing a lot of mapped sites of significance across the country.
I asked this question earlier, so I don't know if you had a chance to listen to that exchange. So I'm looking at your paragraph 2.5, and so the first thing I wanted to ask is, in this paragraph, and you summarised it before verbally as well, is another way to express that Hokonui Rūnanga identified a relationship with Waiwhenua and Taonga across the whole of the district, but we're using the SASM vehicle to express that. And that through this process, that expression has been refined to better reflect the intent, the original intent. So I think you've read it differently, but I just wanted to ask you to think about that question.
I think the point, sorry if I've misunderstood you, Commissioner, that the purpose of 2.5 of my legal submissions, I guess, was to, I'm wondering if there is just a touch of inconsistency in terms of what has been notified, and which of course creates the scope for the proposal, and ensure that we focus in on what the topic is. And if you went to the first objective in the notified chapter, it's quite explicit. It essentially says everything within the district is recognised as sites and areas of cultural significance. And whilst it doesn't use this sort of SASM language, that to me is sort of one and the same. So I think that's probably where some of the confusion has come from some of the submitters in terms of, or questions, sorry, in terms of is the whole district a sort of mapped SASM or not. I think coming back to sort of what you were saying to me, I think there is there's a position advanced by the Runanga that the whole district is significant, but we don't I don't think we've seen the evidence that we would normally expect, taking you through that to get to that particular outcome in terms of the sort of regulatory response that is being promoted in terms of district-wide activity-based approach. I'm sorry, do you want to put your question to me again? I don't know if that answered it.
No, it's told me where your thinking's at. That's important. So the question that I asked Ms. Chadwick earlier today was around the role of the statutory acknowledgements in the Ngāi Tahu Claims Settlement Act, because most of the Gore district sits within the Mataura catchment, and the Mataura River statutory acknowledgement area obviously applies, but also where there are lands and waters sort of that are part of the Mata'o Clutha River catchment or the Oreti River catchment, all three of these catchments have statutory acknowledgements associated with them. And so Ms. Chadwick's answer was that we don't need to retest what is contained in those statutory acknowledgements, which describe the relationships of Ngāi Tahu with those lands and waters. And so then the question I asked her was, so does that mean that those instruments that are sitting in that statute are already telling us that the relationship exists across the district, and that our job therefore is simply to work out how best to reflect that relationship in workable plan provisions?
I didn't hear your questions or the answer this morning. Sorry, I was in something else. But so with the benefit of not hearing anyone else's answer to that, my experience in this area and looking at Queenstown, I guess, as a plan I know relatively well. The statutory acknowledgement areas are identified and recognised in that plan separately from sites and areas of significance, and that flows through, I guess, with a different regulatory response in the plan. So the statutory acknowledgement areas, I guess, are not sort of used as a basis for what we're talking about today. I think if you were to, I think statutory acknowledgement areas is certainly something which is relevant to your decision making. It's sort of, if you look at the rule of reason, it sort of is relevant as to, how parts of the district are recognised in, settlement legislation like you've referred to. I don't think it goes as far as being a foundational evidence to justify the approach that is being advanced. and sort of there may be different reasons for the statutory acknowledgement area. It might be a focus on freshwater, for example, and that might actually be the purpose of that particular statutory acknowledgement. Apologise, I'm not familiar enough with those in the Gore district to probably go into any more detail, but there are particular reasons for them, and that is probably, you know, if it is to do with freshwater, then that would certainly be something that would be relevant to activities to do with probably more a regional council concern, I suspect. But yeah, part of the mix, but I don't think it's determinative for for your recommendations on this.
At your paragraph 2.7, and I'm just going to get there so I know that I'm talking about the right thing. So at the start you've got a statement that the existing operative district plan recognises 6 archaeological sites as being of significance to Mana Whenua. So in this process, these haven't been singled out and identified by Hokanui-Runanga as significant over and above other parts of the district. And then if they haven't done that in this process, to what extent are we would we need to draw from the prior plan, and does this relate to what you're just calling the rule of reason?
Yeah, I mean, it's the point of this part of these legal submissions, I think, is to submit to you that the national planning standards do require this chapter, the Sites of Significance to Maori chapter in the PDP, and that reference there, I guess, is to, you know, evidence. It's just it's an extra over and above the evidence that has been provided that says, look, we do have sites and areas of significance. That's why we're here talking about this. And I'm saying, well, if we've got that evidence, doesn't that demonstrate to us that that this is a relevant matter for the district, and therefore we need the chapter? So that is, I guess, the reason I have referred to existing listings, which you know, we might comment, if they were to be identified, you'd expect to see those 6 sites. And probably more.
Thank you. I've just got 3 more questions, if you bear with me. So this one is paragraph 3.4. So when I was following through this NES argument, I ended up looking at, I know the focus is on B in the historic heritage definition, but I presumed to myself that A also applies in that NES definition, and so therefore the RMA definition of historic heritage would come into play. So the absence of the sites and areas of significance to Maori as described in B, B starts sort of including, so it's not exclusive, and A is leaning on the RMA definition, I would have thought, of historic heritage and its broad nature.
Just pulling out the definition, the RMA definition, which includes sites of significance to Maori, including Mahi Tapu. I don't think that changes the submission. It's captured either way through the definition of historic heritage area as it's used in the regulations.
Yeah, sorry, I'll
So-
try and reframe my question. So when I'm looking at
Okay.
when I'm looking at the regs, and I'm
Yep.
looking at the definition of historic heritage area, there are two parts to that definition in the NES. One of them says, means an area that is protected by a rule because of its historic heritage. So then when I read that, I think, okay, I need to go to the RMA to find out what historic heritage means. When I go to the RMA to find out what that means, yes, it includes reference to sites and areas in Wahitapu, but it also includes reference to cultural heritage, just cultural heritage. So I don't think it's limiting. So I think when I read A, I see the whole of the RMA historic heritage definition, and then when I see B, it's just making sure no one loses sight of the fact that, you know, there will be some areas that are protected because they are sites of significance to Māori, but that's different, I think, to the concept of cultural heritage. I think they're doing different things.
I think the disconnect we have identified is that under the notified approach and the various iterations that have been put forward, there isn't a specific rule that's protecting an area because it's of significance to Māori, and that's, or because it's got a particular cultural quality. The rule that these are included in are, for example, an earthworks rule, and it's, I think the council and the Reneo have made it quite clear that these rules don't exist. They already exist, and we're just adding a matter of discretion or control to them. They don't exist for the purposes. Does that assist?
Yes, I'm following your answer. Yes, I'm following your answer. Thank you. Yep.
Yeah. Yeah. So yeah, I think that's the
key
based approach where you have a matter of discretion or control. The purpose of the rule is not focused on, for example, Section 6E, the relationship. It's something that's going to come through in the consenting process, but we actually won't know until that consenting process has completed whether there is actually a relationship that requires a particular response, whether it be it's a no-go, decline the consent, whether particular consent conditions need to be imposed on the consent and so on.
So, and I'm sorry to labour the point, but when I read A, it says means an area, so I picked up that in your response, which I thought was an important part of your response, means an area that is protected by a rule because of its historic heritage. So now when I read that, it's not telling me that the rule is a, correct me if I'm wrong, and this is where I need you to do this because you're the lawyer, but when I read that, I'm not thinking that the rule has to be a historic heritage rule. I'm thinking that our rule provides some protection over an area because of its historic heritage, but the way that the rule does that is not limited.
No, with respect, I think the words because of are really important there. The area is protected by a particular rule because of its historic heritage. I think the reason for the rule being in the plan is directly linked to historic heritage, and if we were to have mapped sites of significance, then the reason for a particular rule, let's say it's earthworks, within that particular identified area, it's there because of the historic heritage.
Okay, thank you. I was just checking my questions to see if you'd already answered what's sitting there, and you have. So I appreciate your time. Thank you.
Thank you, Sarah.
Thank you.
We'll move on to Ainsley now, and then I guess it's going to be a bit of a tag team for the two of you in terms of the way that you respond to questions. Good afternoon, Ainsley. Welcome, and if you give us a brief overview, please.
Okay, thank you very much for having me today. Look, my evidence considers the approach taken to SASMs in the proposed district plan. It responds to the Section 42A report and supplementary evidence and sets out some practical implications to this approach. In my evidence, I disagree with the conclusion in the Section 42A report that the proposed district plan approach is less restrictive because there are no restrictive overlays within which resource consent would be required. My view is that the approach is more restrictive and certainly less certain. My view is that the Section 42A report misrepresents the way in which SASM overlays in other jurisdictions generally work. That is, in my experience, SASM overlays do not trigger resource consent for all activities. Rather, rules and standards apply to activities within a SASM where those activities may have an impact on the values that make the identified site significant. In the case of the proposed district plan, there are rules and standards that apply to activities that may have an impact on cultural values, but those rules and standards are not related to sites of significance and are therefore not spatially confined. And if we turn to these rules and standards, I understand that the cultural values are defined in Section 2.3 of the Mana Whenua chapter, and activities where effects on those values are considered are set out in policy MWP1. And I did listen to some of the considerations around MWP1 this morning. It is my evidence that the list of activities in this policy is extensive, broad and uncertain, meaning that the majority of activities for which resource consent is required would be captured by this policy. And what I'm saying there is that in most cases, I suspect where a resource consent is required in Gore, policy MWP1 will kick in. It's my evidence. Ms. Beran's supplementary statement includes amendments that refine this policy, and Ms. Scott addressed this earlier. I've compared the two versions of the policy and consider that the refined version does little to alleviate the concerns I express in my evidence. And again, I highlight in respect of infrastructure, the direction in the policy is refined from stating significant expansion to existing infrastructure to the new wording, which is works associated with existing infrastructure that breach required standards, or new infrastructure near the Mataura River, or significant natural feature or landscape, or archaeological site, or not otherwise anticipated infrastructure. And in my view, that changes the scope of MWP1 in a number of ways, but the two that I'd like to highlight are that it's not significant expansion to existing infrastructure, it's any works associated with existing infrastructure now come into play in policy MWP1. And then at the end, it's or not otherwise anticipated infrastructure. And for me, that's relatively uncertain in terms of what you might understand to be anticipated infrastructure versus not anticipated. I conclude in my evidence that the effect and effectiveness of the policy is limited, and I gave consideration to whether, if the policy were deleted, what impact that would have on the implementation of the proposed district plan, and it was my conclusion that it would have very little, if no impact, on actual practice. My conclusion is that the proposed district plan approach is more akin to codifying what an applicant for a resource consent might be required to do in any case, and this is because the proposed approach generally requires a consideration of effects on cultural values where a resource consent is required. And noting before that I think that the majority, at least the majority of resource consents in the district would require that consideration under policy MWP1. And so what I'm saying is that the proposed district plan embeds the consideration that an applicant's required to do in any case under Schedule 4 of the RMA. And in that regard, it's more akin to a consideration of the broader consideration of cultural values as opposed to that matter of national importance Section 6 matter. My evidence goes on to highlight some practical implications of the proposed approach, and in that regard I've made conclusions around the NESETA and the fact that the trigger for resource consent is absent because there are no sites that would trigger the need for resource consent under the NESETA. So in fact, not having identified sites is less stringent for Transpower's activities, but there's also that level of discomfort around, you know, the NESETA not applying as it was intended to do. I also consider that the proposed provisions fail to address notices of requirement. We've traversed that already, and that's even in the guidance material that provides a lot of guidance about what applicants for resource consents might need to do or how they might engage. All of that is very much focused on resource consent activities and gives no consideration to a notice of requirement type process. I've noted that the lack of SASMs doesn't allow an opportunity to avoid from the outset any sites of significance in the development of the national grid. And I've also noted that it's not clear how the proposed approach might impact on notification decisions. And that was traversed again this morning. Now, it's certainly not my suggestion and evidence that where there are cultural values impacted, that notification may somewhat be unnecessary. My concern is that if with a policy like MWP1, it may push the notification test in a way that's inappropriate rather than in relation to effects and then notification still being appropriate, if that makes sense. That pretty much summarises my evidence. I know you've traversed a lot today with Ms. Scott as well as in relation to the earlier planning presentation and legal submissions, but I'm very happy to take any questions, or Ms. Scott and I will tag team as necessary.
Start with Glenys. Any questions?
Thank you, Angelie. 8.7 on page 18 in your submission, and you're saying that you do not agree that the proposed district plan is more permissive. So you consider the proposed range of cultural values listed in MWP1 triggers different thresholds and more frequent. Do you consider that these activities listed are actually that need consent are more frequent than the operative district plan, because there's only 16% of the activities that are in need of consulting with Mana Whenua?
Are you talking about, is your question related to, is it more restricted from a consultation perspective, or the point made in my evidence, which is it's more restrictive than a typical SASM approach? That the comparison I'm making in my evidence is where you might have what was referred to in the 42A report as a more common approach to SASMs, and I was making a comparison between that and the approach in the proposed district plan. And my suggestion is, because of the amount of activities listed in MWP1, along with the lack of a spatial component, means that the provisions in the Gore district plan are more restrictive than you might see in a more typical approach. So that's the comparison I'm making, as opposed to with the operative plan.
So then you would agree that the operative plan is just as permissive or restricted as the proposed plan?
I probably find that question very difficult to answer. I think the last time I was involved as an applicant or assisting an applicant was for the Gore Hardtee, and in that case, of course, it was a designation. I haven't had enough experience with the range of provisions in the operative plan to answer that with any amount of certainty.
So guess a question that arises, and it may be for Rebecca, in that the operative district plan does not show sites, and the proposed plan doesn't show sites. So when Transpower is going through its sifting exercise in terms of working out routes, what is the difference between what you've had for the last 20 years and what is proposed in the proposed plan?
Who's going to take that one? I understood that the legal submissions noted that there were 6 sites that are identified, but I take your point that there may be no difference between what's in the operative plan.
I'd just add, I mean, there may be no difference in terms of what is in the operative plan. Well, actually, I'm sure there will be some difference. There'll be a different regulatory approach sitting behind that, I imagine. I'm not familiar enough with it to comment, but I don't think that's the problem here. I mean, Transpower involves itself in almost every policy process across the country, and it is doing that, I guess, in a way to try and ensure consistency in matters that it needs to grapple with, given its linear infrastructure traverses most districts and regions across the country. I think that as we, I guess, all get more sophisticated and in our plan making, we now have national planning standards. We also have the national policy statement, which didn't exist 20 years ago. So I think that I don't know. I'm not sure it's the right question to be asking, or the real problem that we're trying to deal with. What we're continuously trying to get, I guess, is certainty, efficiency, effectiveness in terms of how the plan is ultimately implemented once it becomes operative.
Sarah, can I add a thought to that as well?
Please do. Yeah.
I think Ainsley and Ms McLeod and Ms Scott have covered it pretty well, but I suppose the difference from an operational perspective from the last 20 years, looking forward 20 years, you would have heard the evidence of Mr Sutherland way back in hearing 1 that talked about electrification, and this is covered in Ainsley and Ms McLeod's evidence too, that Transpower will need to respond to the electrification of the economy, and as such it will be needing to upgrade its infrastructure significantly and provide connections to new renewables. So to Ms Scott's point about the need for efficiency and clear information, the next 20 years are more important from the perspective of building new assets than the previous 20 years were, when we probably thought prior to the Paris Accord that electricity demand was likely to level off. So that's a significant change for us in terms of a desire for a greater level of certainty from an operational perspective.
Marie?
So my questions actually just work through your evidence, and so when I come to them, it may be that you've already answered some, and I'll skip them if you have. I guess I wanted to start at your paragraph 1.6, and just, it really goes to a question that was asked of legal counsel as well, which is that, do you accept that it's not really for your resource users to determine on behalf of mana whenua how they should manage their relationships with waiwhenua and taonga? So the reason for asking that question, obviously, is what we've got in front of us is Hokonui Runanga saying this is how we want to manage our relationship. And I think it goes to maybe the perspectives involved. So we've got a perspective from Transpower with a purpose and an NES, and that's coming up against the perspective of Hokonui Runanga. So would you accept that it's not for anyone else to determine how that relationship is to be managed?
Yes, I accept that, and in fact, I acknowledge that that's included in that same direction is included in the RPS, and when I address the RPS a little bit later, I acknowledge and agree that, and further, I do go on in my evidence to say that doesn't happen in a vacuum. It also needs to be cognizant of what the RMA tells us we do in the context of a district plan. So, you know, absolutely yes, I agree, but I also note that the content of the district plan and the things the district plan does is a little more confined than perhaps the breadth of values and relationships.
And that confinement is related in terms of what jurisdiction the district plan has to manage certain types of activities?
Yes, I think so, and the way in which the district plan can recognise and provide for the relationships. There are only certain things a district plan can do in relation to those relationships, but I'm sure those relationships are deeper and broader than the task of a district plan.
Nicely put. So now my next question isn't until your paragraph 6.2, which tells you that I was following you quite well, and I'm going down to 6.2, and my question was really wondering how much thought you'd given or attention you'd given to Appendix C to the Section 42A report, and where you've got that big analysis of the activity classifications and the triggers, the matters for discretion and control, and where things that are relevant to the national grid pop up in that.
Sorry, can you ask that question again in relation to paragraph 6.2 in my evidence?
Yes. So it's thinking about the types of activities, so the types of activities that the matters for control and restricted discretion are identified, or that the rule is discretionary. So I guess what I'm getting at is that's the place in the evidence at the moment that has captured what is permitted, and then when things are triggered to have resource consent, what's the classification for that, and does it have a matter of control associated with Ngāi Tahu cultural values? So it's the analysis that's responding to worries about we don't know what this is doing, we don't know how this applies, and yes. So that's where in Ms. Bennett's evidence she's trying to respond to that concern of submitters. So I guess what I was asking was, have you had a look at it to think about those activity classifications that are relevant to the national grid?
Yes, well, I think that the activity classifications in the most part are irrelevant to the national grid. And that's because when you're talking about an existing line, that would be consented where consent would be required under the NESETA, and it's quite possible that any new line would be a designation. My concern about the policy doesn't really relate to controlled activities or restricted discretionary activities. It relates to more how that policy would apply to a fully discretionary activity, a non-complying activity, a designation or a resource consent under the NESETA. Bearing in mind that I understand that the drafting purpose of this policy is to connect to those matters of control and discretion, the reality is that that doesn't take away from the statutory requirements to consider the objectives and policies of the district plan in a designation process, in a resource consent under the NESETA, or more broadly, when you're thinking about a discretionary or non-complying activity. So my evidence perhaps steps back a little bit and says it's not so much there's a matter of discretion in rule X, rule Y, rule Z. My concern is that this policy sets out a broad range of activities and uses quite broad expression in places that would give rise to a consideration in those other types of processes.
So yes, right. So what I was picking up from the legal submissions, and you've just done it quite nicely now too, is that really the big issue for Transpower is the objectives and policies, and that's why MWP1 is highly problematic at the moment. Yeah. So if you were listening earlier to that exchange with Ms. Bennett and the idea that maybe it just needs to be stripped back to to describing those, the way in which the plan is functioning. So going back effectively to what it was, something like what it was before the minute 15 response, and that the list that's sitting in MWP1 becomes explanatory text. It wouldn't, and then if I read out what I'd scratched away and put across to Ms. Bennett, I'm just going to test it with you. You don't have to answer on the spot if you don't want to, but I'm going to anyway. And I've modified it since I read it out to Ms. Bennett because of Ms. Chadwick's legal submission. She had a nice wee phrase. I thought, well, that makes a lot more sense. We'll use that. So I'm just going to read this out. So if the matters disappeared and became explanatory text, which you sort of indicated, it looks like explanatory text, so maybe that's what it should be. But if it was, the effects on relevant Ngāi Tahu cultural values are considered when resource consent is required for activities that have potential to impact on those values through matters of control and discretionary considerations. Now, at the moment, it says resource consent. I mean, it could say something else there, like when decision making is required or something. Does that kind of do it? Would that take away some of the concerns if there was just a way of handling this policy that split out its content?
Yeah. Well, perhaps shooting from the hip a little, one concern or one question I would have is what happens for fully discretionary and non-complying activities, as well as designations that you have highlighted. That would mean that policy doesn't direct a consideration of the effects on cultural values or the expression used.
I was wondering if I was wondering if the phrase discretionary considerations expanded itself beyond restricted into fully discretionary or discretionary in a non-complying process. I don't know. Yeah. The point that you're making is it would need to.
You could do something to talk about the way in which the effects on cultural values were managed, and then have more than one bullet point, or have it as an including by matters of control and discretion. But I'm shooting from the hip here without the words in front of me. I did listen to this morning, and I was particularly supportive of that. The comments made around the more you add to this, the harder it gets, and the more you start talking about what's in and what's out. And I think you've seen that same theme come through in my evidence as I've worked through those various clauses and sort of said, this is a problem here, I don't understand that here, and why are telecommunications important here, that kind of thing. So I do have some sympathy with the approach that has been attempted in response to minute 15, and I would support further consideration to more explanatory text and a policy approach that says a little bit more around, how the outcomes and the objectives are being achieved in this plan.
Yeah. So it's more generally explaining to us what the how the plan is intending those
Mm.
provisions.
Yeah, that's right. But of course, the devil's in the detail, and I'm not sure it would resolve the predicaments plural perhaps raised by my client.
If I can just add, of course, an explanatory note also has no legal status, and there's clear case law on that. So depending on what might be put in that note, I think you need to be very careful that it wasn't something that actually needed to be given weight, or that might need to be relied on by whoever it is in an actual consent application or designation. For example, if you were designating, the explanatory note would have no legal weight at all.
Can we just take a break for 1 moment, please? Just to highlight, just so that people are aware of the conversation that I've had behind, there is a council meeting happening here this afternoon, and so we need to remain focused. Probably we've got about half an hour maximum. Back to you, Maria.
Okay, I don't have too many more because there are lots of them we can skip past. So, and there's not that many anyway. So, at your paragraph 8.9, this issue of interpreting the RPS policy TW.4b. Now I've got to find that. Oh, actually, it's sorry, it's unhelpfully. Oh, so it's your paragraph 8.9c, where it's got policy TW.4 from the RPS, and then you go down, and then it's got B. So it's on page 19 of your evidence, and so when I read that, it says recognises that only tangata whenua can identify their relationship. So it's that there. So
Yes.
you're not.
Yes, and that's what I was referring to earlier in my response to you.
Yes. Okay. So that we can move past that. Then 8.10, where you were wondering about. I think you were wondering about utu and te reo Māori, and I just wanted to test that. Do you think maybe they would fall into the taonga category, in that, like utu might be talking about balance and relationships between people and the environment, and use of te reo might be about names and terms used in effects assessments, so that kind of idea. Does that sort of is that enough to address? Yeah.
Yes, look, I note that the supplementary evidence from the Runanga has suggested that those two values, the commentary in relation to those two values, be deleted, and I probably would note that I support that. Yeah, I accept that they may fall within the subsets of some of the values. To me, they stood out as being somewhat distinguished from the RPS direction. And perhaps while we're just on the RPS, this morning it was suggested that I'd identified a conflict, and I don't think my evidence goes so far as to say that. My evidence just acknowledges what the RPS says needs to be done, and highlights some differences in language, and highlights the direction given. I don't think it goes so far as to suggest that there's a conflict between the approach taken in the proposed district plan and the RPS.
So actually, I'll pick up. So this was when legal counsel were talking about the way that things might have to happen if there are no mapped SASMs, and that it could be that ACRE approach deals with all the other mapped items, then goes to the Runanga with, okay, we've managed to try and seek to avoid these things as much as we can, and here we are now coming to talk to you. And this is something that's going to be a matter for new development, so not existing lines presumably. Do you see that at that point, trying to draw out the cultural expertise you need to navigate the last bit of the alternatives and options, is that feasible?
Yes.
And
Well, I think that's absolutely what occurs. Look, this morning there was a suggestion that there was some software algorithm that Transpower holds that somehow you put in all the district plan data and it spits out the answer. It's certainly not that. It's a very thorough, rigorous and expert advised process. Ms. Ng can probably talk about this a little bit more, but there's at the area stage, it's a very large search area, and that's at the point where it is a desktop exercise, and there's an attempt to map every Section 6 matter at the very least, and in Gore, without identified sites of significance, it's not to say that archaeological sites won't be identified. So some sites of significance may come through that desktop exercise, but then there's no question there becomes a point where the cultural expertise and mana whenua would need to be involved. Perhaps the concern expressed by Transpower is a little bit, you wouldn't want to have made the wrong choice between the area and corridor stage, where there might have been a choice to avoid something very significant early on, and effectively establish those no-go areas from the outset.
so when I was thinking about this and thinking about the evidence that we've had in this process, I wondered that because right back in hearing stream 3, we had all the evidence around the tools and methodologies that Hokonui Runanga prefer to use, and one of which is Apiri Hono Tātai Hono, which was included in the text of the plan initially, but is now just referring to methodologies in the later evidence. But that if you were setting about to do an exercise like this in the Gore district, that assessment, I was thinking to myself, could readily inform perhaps the ACRE process. So to me then it was about the stage at which the engagement occurs potentially, i.e. that the without the mapped SESMs, then there would be a need to draw on the iwi management plan material, other material that's available, but also tools and methodologies offered up by Hokonui Runanga, and that might in itself assist depending on which stage you engaged. Yeah.
Yes. Look, there's no doubt the material is useful. I think maybe Ms. Ng can talk about it a little bit more, but it's about ensuring that all those Section 6, for me, all the Section 6 matters are treated equally, and if the information about some Section 6 matters is better than others, then role choices could be made. The higher quality of information at that desktop. Hey, we've got a project, we need to go between A and B, and there's this massive search area. The better information and input at that desktop stage is certainly beneficial. Probably to the environmental outcomes and Transpower.
Do you mind if I just add something there? So I spoke about sort of the two potential times for consultation, and the first is sort of coming with a blank piece of paper and saying, okay, help us out. Where should we not put this line from your perspective before we start mapping other matters of national importance? The second is the, bringing in all the matters of national significance where there's, available information, whether it comes from the plan or elsewhere. But I think that the concern that we have is if we don't have that, what we're, I guess, hoping for is those sites of significance to be clearly identified at that point in time. We're thinking about this practically. If we then come to the runanga and say, hey, we've done all this work, we've identified all these other things, and this leaves maybe 2 options for us for where this line might go. And if the runanga might just be like, oh, no, we're not, don't go there. Would say, okay, well, we'll work through that, tell us why. And once we understand that, if we basically will add those overlays to our work, and then we'll go, well, okay, where next? Because we then are going to have to, I guess, look at all of the matters of national importance that we've identified and start to weigh up, I guess, which ones are, look at the values of each and why they're protected, and try and work out, well, actually, where we're going to put this line. But so we might look elsewhere, but then we still don't know if there's another particular no-go area from a cultural perspective. So I guess that comes back to that efficiency and effectiveness, is that it's coming too late into the process.
Is the alternative, because you've presented 2 kind of alternatives at the earlier stage, before you've gone too far down your desktop exercise, in this district, it might be that your engagement does happen at the earlier stage, understanding the position of Hokonui Runanga, and that it's not a position without available tools and methodologies to support your process. I think it might be different if it was iwi and hapu that weren't as well developed in terms of tools, methodologies and structures to be able to do stuff, which does happen in other parts of the country, but it's not the situation that we've got here. So is it really, and which was where I was going to with my question with Ms McLeod, is it just the point at which in your process you engage?
Who's answering that?
You've unmuted your mic, Missy.
Yeah. I think that's probably correct, Commissioner. A practical difficulty that I can think of with any project of scale is that it might be a proposal that we've got a start point and an end point where a line may need to traverse through, and Gore might be just one of the districts that forms part of that study area. So in absence of any more specific information at the desktop stage, there would be a gap in the broader analysis.
But there's no reason you couldn't seek it at the desktop stage.
Potentially, but the scale of it becomes potentially really significant. And to what extent is the runanga, I guess, resource to be able to respond?
That's, I think,
for a project of scale.
Yeah, so that's, I think, why I was saying what I was saying before, because the evidence in front of us is that there is a tool and that there is a resource at the Hokonui to do it. And I think we wouldn't be having this conversation if either of those 2 things were not true. But they are true based on the evidence we've received, and that does change this conversation, I think. So that's as far as we can take it, probably. And then,
sorry, just to wrap that up, I think I wonder if I'm not sure if that evidence is focused on, site by site property ownership applications where someone's considering just a very specific piece of land. I think the position that we're advancing today is different, because we would actually be coming in asking for information on the entire district.
That's what I'm telling you, is the evidence.
So it's a much more intensive response I think we would be asking for.
So can I just, the reason that I'm having this conversation with you, and just it might mean that you're not as familiar with the evidence that we've received earlier in the process in hearing stream 3, because what we have had in this process, which is different to any other process that I've been involved in, is that the tool that's used or can be used is at a full landscape scale and a full district scale. So the exercise, all I'm saying is that we've got evidence in front of us that the exercise could be supported, that there is tools and methodology to do it and resources to do it. The evidence for that is sitting back in hearing stream 3. So that's just to let you know. Yeah. So, very last thing is I just wanted to check that in your paragraph 8.3.4, a real easy one, Ms McLeod, is did you mean here regulation 35 in your paragraph 8.34, which I suspect you did, but at the moment it says regulation 31.
Quite possibly. I haven't got the NES in front of me, but that's quite possible.
I just didn't want to know that I was missing a reference to something other than regulation 35. Yeah, because 31 was just about tree trimming or something and it didn't seem to work. Yeah.
Yeah, my apologies.
Cliff, you had a question? No, I've got. Okay. All right. So, Team Transpower, thank you for that. You've raised some very interesting issues, in particular, that will generate some questions to the Runanga tomorrow. For example, have they had regard to the designation process and the wider considerations that you've been talking about? So it's been a useful talkies there and the evidence that you've presented. So thank you for all three of you appearing today. And if there's nothing else, then we will move on.
No, thank you for your time, and also thank you for accommodating us online as well. We appreciate it.
You're welcome. All right, so we
Thank you.
will.
Thank you very much.
Cheers. We will now adjourn then until 8:30 tomorrow morning, when we will be hearing from Courtney Bennett, and followed by Federated Farmers and the Hokanui Runanga. If the panel can just meet out back briefly so that they're able to set this room up for a council meeting.
Sorry, I have sought comments from the other parties for tomorrow morning, and at this stage they're relaxed about the timeframe being pushed back. Or certainly Hokanui Runanga has confirmed that's fine. I will just chase up Council for Food Farmers just to make sure and share that with the hearing team.
And if that happens after hours, please contact us direct rather than through council. Thank you. So we are adjourned until tomorrow morning.